I hope you're all excited. I am. And we are here to celebrate the scholarship of Prof. E. And just a few announcements. So please switch off your phone or just keep it on silent. And then I will ask you to stand once the procession comes in. And then I also want to ask you to please remain standing, if you are able, for the national anthem. So I'm just waiting for colleagues to give me the go-ahead. You can please stand for the procession. Thank you. Good evening, ladies and gentlemen. Please be seated. Welcome to this inaugural lecture of Professor John Mark E. I want to welcome the Dean of the Faculty of Law. Well, I want to welcome Professor E, the Dean of the Faculty of Education, and all the representatives of the other faculties, deans, as well as the HODs of the various departments, as well as Deputy Dean Research in attendance. Thank you so much for being here. This is a celebration of Prof. E's scholarship. I'm so excited, Prof. And we will now be listening to the Dean, who will do the introduction and the welcoming of Prof. E. Thank you, Dean.
Thank you, Professor Nokia. Professor Madiba unfortunately couldn't be here tonight, Yes, so I'm not Professor Madiba. So colleagues, students, family and friends of Professor Iji, Professor Iji himself, our man of the moment, Professor Strydom, who's here, who will be responding. And thank you to the three faculties who are here as well, and to the HODs. It's my privilege to welcome you to this very important event, inaugural lecture of Professor John Mark Iji. An inaugural lecture, of course, is a very special moment in the life of a scholar. It's a celebration of academic achievement and also an opportunity to share the insights of years of dedicated research and teaching. And it's also a chance for family members who may wonder what this person is getting up to every day to learn something about what is going on in that head. So this afternoon, with us gathered to honor Professor Iji's appointment as professor and also to learn a little bit more about his work. And thank you to all of us for joining us in celebrating this milestone. Professor Iji joined UWC in 2020 from the University of Venda. The Dean of Venda is still cross with me for bringing Professor Iji here. He became a full professor on 1 January of this year, and he has been the director of the African Center for Transnational Criminal Justice since 2021. This was a re-establishment of the center, and that happened under the leadership of Professor Iji. Professor Iji holds a doctorate from the University of Johannesburg, which he obtained in 2014, I think, under your 13. At Wits, oh, I got myself confused, sorry. Thank you for that correction, so from Wits. And he also holds a C1 rating from the National Research Foundation. He has successfully supervised a number of PhDs and masters. I asked him today to give me an update, but he was too busy preparing for his inaugural lecture tonight to give me exact figures. But among his publications are at least 3 books that he has written or co-edited or edited. He's also the editor of various journals, and he has networks across the globe, including Germany and Nigeria. Professor Iji, we look forward to listening to your inaugural address tonight. Please come forward.
Good evening, colleagues, students, and family and friends. I want to begin first by expressing my deep appreciation to my family. One of the paradoxes of being the last child in a family that is large is that you're faced with both the disadvantage of perhaps not having both parents before you even are old enough to contemplate your future, and also the advantage of leveraging the benefits and sacrifices of your older siblings. So it's on this note that I pay tribute to my late sister, Ehigegbame Utabo, who passed on in December last year. She gave me education, and not only education, but the tool to liberate myself and also to empower others, and gave me the encouragement to know that one needs to constantly strive and never cease to struggle for a society that is free and equal in a world that is dangerously teetering on the precipice of catastrophe. I was born in ancient Benin Kingdom in Nigeria. And if you know a little bit about Nigeria, you will know that Benin City is situated on the west coast of West Africa. And Benin City, at a point in history, was regarded as one of the most advanced and most developed country in the hinterland of West Africa. That was before its encounter with Europe's explorers. Some of us are familiar with the Benin bronzes, which by some accounts may be over 4,000 scattered across museums, mostly in Europe and North America. But now it's subject of ongoing litigation and struggle for return and reparation. The international circumstances in which the artifacts and cultural objects were acquired it's not the focus of this lecture, but I raise it just to highlight the enduring effect of history and how it impacts our daily lives today. This particular experience has a background, historical as it were, also shaped my own intellectual identity and ideological commitment, and of course, my commitment to produce a body of scholarship that is dedicated to promoting a better and fairer world. My scholarship, informed by this experience, is rooted in Afrocentrism, historically conscious of the African experience with international law, and culturally grounded in the realities of the African condition in our contemporary world. I'm aware that others also engage in this kind of scholarship, but just to set out my own positionality as an academic. The earliest recorded interaction between Benin and Europeans was probably in the late 1400s, when the Portuguese arrived in the Niger Delta of Nigeria. Of course, there was no country called Nigeria then, but the intercourse over the next 400 years between the Portuguese explorers and then Benin Kingdom was one that was rooted in mutual respect and cultural exchanges, diplomatic exchanges, and this particular kind of relationship lasted for about 400 years, such that the Portuguese explorers called Benin the great, quote unquote, city of Benin, an expression by European standards of that time that was perhaps only reserved for cities like Lisbon, France, Paris in France, and London in the United Kingdom. So one would pause to ask the question, what would make the Portuguese refer to a kingdom in the dense rainforests of West Africa as a great city? And at what point did that change in terms of subsequent European encounter with Benin? One's reading of history suggests that perhaps this was influenced by natural law theory. And back then in Europe, natural law theory greatly influenced how international law was conceived. Natural law theory orientation of international law was based on the assumption that society is made up of man. I use man here in, I would say, pre-modern sense. That conception regarded society as made up of men, and as such, when you equate that with states or nation state as it were, you naturally would have equality. So just as a man, whether he's a dwarf or he's a giant, is a man and a human being possessing of basic characteristics of a human being, whether big or small. State also existing in the state of nature were of equal stature and should be treated equally. So it is safe to conclude that the attitudes of the Portuguese in their relationship with Benin, though outside the European world, was influenced by this view. In the 18th to 19th century, there were significant shifts in Europe to explain the change in attitude by the time the British arrived in Benin City. The rise of positivism and its influence on international law in the 19th century, the construction of racial hierarchies, civilized versus uncivilized, arguably influenced the British attitude in their colonial encounter with Benin. So, when the British arrived in Benin City, of course, there were interactions prior to 1897. The British colonial expansion had been ongoing, but they've tried unsuccessfully rather, to establish control over Benin. This was stiffly resisted, and this happened around the same time that the Berlin Conference took place in Germany. So unlike the natural law philosophy of St. Thomas Aquinas and the system of legal rules of the Roman Empire, which propagated a universalist vision of the equality of family of nations, there was a movement towards positivism in Europe in the 18th and 19th century, towards a system of law of nations based on free consent. And what that meant was that nations who met the standard that European states or nations, as it were, had agreed were deemed to be qualified to be admitted into the club of civilized states. So at the time the British arrived in Benin, this consciousness had already taken roots and influenced their conception of international law. When the British arrived in Benin, the king had refused them entry and insisted that the Benin were having a traditional rights and the Oba was not allowed to receive foreign visitors. The British insisted, and there ensued a conflict between Benin and the British visitors, leading to the killing of certain British officials and the ultimate Benin massacre, which some of us may be familiar with. And what you have here is the head of a queen mother, one of the Obas of Benin, which is today sitting in the British Museum. So this is the historical consciousness through which I study international law. The conception that Europe developed international law is true, but only to the extent that it was a set of rules that was developed among European states and applied to European states. The moment Europe began to globalize and try to universalize what was essentially a European common law, then the issue of what country or state was qualified to be admitted into that club of exclusive states then arose. And that defined the confrontation between Europe and Benin. Now, if we look at the map of the world, especially Africa in the early 20th century, we would find that most of Africa has had just maybe a decade before the beginning of the 20th century, most African countries were still not entirely colonized by European powers. But right after the Berlin Conference of 1884 to 1885, that process of colonization accelerated. The entire system of international law as conceived by Europe was essentially for perhaps managing conflicts between themselves, and one of such instances was the whole idea of colonization. Because from the process of the Berlin Conference, the European colonizers managed to avoid direct conflict. Don't forget, they were establishing colonies across Africa, and there was the tendency that there will be contestation between who owns what and where. So the Berlin Conference helped them to manage that process of colonization. The first major crisis emerged in the First World War. And we can see here on the map that if we put international law in colonial context, we had at the League of Nations 4 African countries who were at the establishment of the of the League of Nations. You have Liberia, you had Egypt, the Union of South Africa, and Ethiopia. But because international law by design was founded on exclusion of countries that were not conceived to be qualified to be members of the civilized club, they were excluded from getting a permanent seat on the Council of the League of Nations. So the idea of marginalization that we try to grapple with today is not entirely new. From the very beginning, Africa had existed on the periphery of international law. And then came the Second World War. After the Second World War, which was another major crisis, major European powers had the opportunity of re-establishing a new global order founded on international law. Again, that particular order was established at a time when most of African countries were still under the yoke of colonialism. But there was the Union of South Africa, Egypt, Liberia, and Ethiopia are the dominating oak in the United States when the United Nations was established. What the great powers did essentially was to reconstitute themselves into the 5 permanent members of the UN Security Council. And once again, no African state was deemed qualified to have a seat on the council. So we see that the privileged positions of great powers continued both after the First World War and the Second World War. From an African perspective, if I look at the history of the League of Nations and the United Nations, what is significant for me is that international law itself seemed to not just marginalize Africa, but perpetuate that marginalization in a way that legitimizes itself as a legal system that perpetuates this marginalization. I'm simply saying that if you look at the League of Nations, after the First World War, Germany was defeated. There were countries that were former German colonies. And one would expect that the League of Nations would have granted those countries that were former German colonies, but that were taken from Germany, would have granted them independence. But what the League did was to transfer those countries to another colonial power. In other words, it had, again, put the seal of authority of colonization on the process of colonial exploitation. The second is that from an African perspective, no African country was granted a permanent seat either on the Council of the League of Nations nor in the Security Council, even though they were part of the process. So we can see that if we look at the League of Nations, Article 22, its own conception of the state of Africa and Africans as a people, it speaks of a people who are not yet by themselves qualified to live independently. So in other words, they are not adults, so to speak. They were incapable of governing themselves. So they had to be governed by a more well-resourced, more experienced, more modern state. And what that suggests to us is that international law, from its historical origin, has been defined and shaped by this legacy of marginalization of Africa. So, nevertheless, the architecture of the post-war international legal order under the United Nations rests on key cardinal principles under the Charter. The principle of prohibition of the use of force, the principle of non-interference in Article 2.7, and the principle that establishes the powers of the United Nations Security Council has recognized by states that the UN Security Council, anytime it acts on their behalf in terms of Article 24 and Article 25 of the Charter. Although the principles in the UN Charter are quite often violated by powerful states, and sometimes in a very flagrant manner, it is generally accepted that it still represents a set or a system of norms that constrain state behavior. The UN will mark its 80th anniversary this year. In all those years, only during the 1962 Cuban Missile Crisis did the world come close to the kind of crisis it is facing today. It is no longer news that the current global order is eroding. What is unsure is what kind of system is going to replace it. But how did we get to this stage, one might ask? And that will take me to the next, sorry, I just left my slide there. The sources of the current crisis in the international legal order. For me, I identified three major sources of the current international legal crisis that we face. We have seen that by the 1800, just before the Berlin Conference, only 10 to 20% of Africa was under direct European colonial rule and occupation. However, on the eve of the First World War, 90% of Africa had come under colonial rule. Accompanying or perhaps underpinning Europe's economic, social, and political entanglement with Africa through imperial globalization were these sets of international law, rules, and practices that were developed and applied by European states, such as statehood, sovereignty, equality of states, and diplomatic immunities, non-intervention. So we see that these principles are, however, being routinely violated today, not by African states, but by powerful states. And over time, this had produced such effect in the system that even countries are beginning to doubt the efficacy of international law. So when we speak of the three major sources of the current crisis, I say the first is the question of the justice and fairness question in international law. So to what extent do the institutions of international law consistently and adequately apply the substantive rules and procedural rules of international law adequately and across board without prejudice or without discrimination? We do not need to go far to answer that question. We can take a look at what is happening in Gaza to understand that issue. The second source of the current crisis is the legitimacy crisis. With this, I'm asking the basis of authority of a body like the United Nations Security Council that is undemocratic and unrepresentative to claim that it legitimately acts on behalf of humanity when it takes action. Here, I'm not talking about legal authority because that much is clear from Article 24 and 25. I'm talking about sociological legitimacy. Perhaps with the exception of China, one can look at the UN Security Council and its composition, that much of humanity is left out of that council. The third source of crisis is the credibility crisis. And here I'm referring to the degree of responsiveness of the institutions of global governance to address the concerns of the third world. We can talk about the Rwandan genocide and the ongoing conflict in the DRC. So we see that the deepening crisis is manifested across international legal regimes. The genocide in Gaza has raised questions of international humanitarian law and human rights law as much as it has challenged the issue of justice and fairness in international criminal law. The bombing in Kosovo in 1999, the US invasion of Afghanistan in 2001, the US invasion of Iraq in 2003, the NATO bombing of Libya in 2011, and the Russian invasion of Ukraine, all of these in clear violation of Article 2.4 of the UN Charter. These are only a few of the most egregious violations. The tariff war that is ongoing and the inability of the WTO to assert authority is tearing down international economic law regime. The UN system and international law is under pressure like never before, and it is during a time of crisis like this that fundamental reforms sometimes occur in international law. As a consensus-building mechanism, international law relies on cooperation among states. It relies on negotiation, it relies on mediation, and today no single state can claim to be able to impose its will on the others, at least not without some challenge. There will be areas, as it were, where departure would be necessary, where assertive continental sovereignty will be necessary, and there will be areas that will be amenable to accommodation of collective and community interest. At the same time, the areas where any hope of possibility of reform has been swept away makes it imperative that perhaps state may resort to acts of illegal international legal reform. And I will come to what I mean by that shortly. I think Africa does not have to look outwards in this kind of crisis. It has to look inwards, neither looking east nor looking west, but looking forward, as Kwame Nkrumah once said. The present crisis represents a second Bandung Moment in the making of a new international legal order for Africa, but what does illegal international legal reform imply in the case of Africa? When I speak of illegal international legal reform, it may seem like a contradiction in terms, because when you talk about legality, it invariably rules out illegality. But here, these two opposite terms are brought together. States and international organizations usually acquire powers either by direct authority in terms of their constitutive instrument or by delegation. International lawmaking is usually a slow process. The conventional method and customary international law is even more so. So what do international organizations sometimes do? They often increase or expand their scope of authority incrementally, and they bring about reform by expanding their powers and scope of authority. For example, by reinterpreting what constitutes threats to international peace and security, the UN Security Council has been able to carve for itself a legislative competence scope within the UN Charter. This was never contemplated within the United Nations Charter when it was drafted in 1945. On a second note, we can also look at international organizations and the way they acquire authority in this sense of illegal international legal reform, and draw example from the United Nations activity, especially the UN Security Council, when it changed the rules in terms of how its own voting pattern is conducted. Naturally, as provided in the United Nations Charter, when they vote on the Security Council, if a member state is not present, then its vote ordinarily would not be counted. But we see now, if you look at the UN Charter as it were, it did not originally provide that when a member state abstains, its vote would not be counted as a negative vote. So we see that international organizations sometimes arrogate emergency powers to themselves, powers not hitherto conferred or delegated to them by simply appealing to the extreme and unusual circumstances in what may be called authority leap, or what international relations scholars may call exceptional authority leap. What international relations scholars call authority leap, international organizations exceptionalism, international law would call illegal international legal reform. At first, we see that this practice developed in international law, particularly during the Second World War. We see that after the Second World War, the Nuremberg Tribunal was established, but there was no provision to try the kind of crime, especially in relation to the crime against peace, and in terms of Article 6A of the Statute of Nuremberg. But the Allied powers, who were the victorious powers, never really bothered about legality at that stage. What was important was to make sure that the atrocities that were committed were prosecuted. And they went ahead to prosecute the Nazis. So we can take that as one example of illegal international legal reform, because the law did not exist at the time the crime was committed, but the crime was nonetheless defined in a written law, and the law applied retroactively. So perhaps another good example is what we see in Article 27.3 of the UN Charter. When it became impossible to introduce reform through the formal processes. Other examples of illegal international legal reform include the redefinition of the meaning of threats to peace and security, enforcement action under Chapter 7 of the UN Charter, and other regional organizations who have also implemented illegal international legal reform, like ECOWAS and the African Union. So this was why the AU came under criticism when it first adopted Article 4H of the Constitutive Act of the African Union and Articles 16 and 17 of the African Union Peace and Security Council Protocol, contradicting Article 24 and Article 53 and 103 of the UN Charter. Here I started to pay attention to illegal international legal reform in my contributions. In 2016, I tackled the question of whether or not this act of illegal international legal reform can stand the test of legal validity. In my contribution on a new protocol that was adopted by ECOWAS and the African Union at the time, I examined the question of the legality of particular provisions under the ECOWAS mechanism on conflict prevention, management, peacekeeping, and resolution, and its compatibility with the United Nations Charter framework. Then again, in 2016, I had the urge to revisit that question, because articles and materials that had emerged had come, I would say, to question the African Union legal framework. In my contribution on African Union and ECOWAS intervention treaties under international law towards the theory of regional responsibility to protect, 2016, I then decided to offer a defense of the AU and ECOWAS legal framework and consider the question of illegal international legal reform and the objections that were raised against this particular approach to bringing about moral improvement in international law. My contention was basically that when we focus so much on the formal processes of law reform, we sometimes miss the opportunity to bring about improvement in the law. And in doing this, I refer to the Nuremberg example, pointing out that even though Article 6, paragraph A of the Nuremberg Charter was illegal at the time the tribunal implemented it, it went on to become one of the most fundamental improvements in international criminal law today because it forms the basis of the law of the crime of aggression under Article 8b of the Rome Statute that we know today. The act actually began as an illegal act, but which quite often academics prefer to call it as an example of victor's justice. So now that Africa is at this crossroad, what should Africa do, and how should it go about it? But just before I explain how Africa should respond to the moment, I will just quickly look at how Africa had responded to previous critical moments or critical juncture in history. The first was the Cold War moment. When the Cold War ended, Africa tried to introduce particular reforms. Those reforms were first tried during the Cold War, particularly the issue of new international economic order. We all recall that after independence, most African countries, shortly after independence, most African countries started struggling, and then they pushed for introducing structural changes in economic relations between the global south and global north, which was not successful as it were. Then they moved on to the right to development, which again did not yield any result. So from that experience, Africa's approach and then to that first critical juncture was not successful. The second critical juncture, they also, I would say, I call it the unipolar moment. That unipolar moment, one could take from 1991, for example, when the Berlin Wall collapsed in 1989. The 1991 ascendancy of the United States has a unipolar global power. What that meant was that Africa and other countries that had previously depended on the East-West rivalry lost patrons, they lost support from the US and the Soviets, and so it became difficult for them to sustain themselves internally, and most of them collapsed and relapsed into civil war. In my contribution with Professor Imehele and also my own single-authored contribution, I've examined this particular issue and how they contributed to the current crisis that Africa is facing, where conflicts that have roots in the Cold War and the arms that they flooded the African continent with continue to fuel conflicts across Africa. So we look from 1990 and 1991 down to 1997, ECOWAS and Africa opted for illegal international legal reform. The first was to establish, to adopt a treaty, the Protocol on Conflict Prevention, which I mentioned earlier. Now, that particular treaty, even though it mentions the United Nations Security Council, did not provide for the requirement of authority of UN Security authorization of UN Security Council before the regional organization can embark on the use of force, which was a flagrant violation of Chapter 8 of the United Nations Charter. Then the African Union, in its own report in response to the Rwanda genocide, established the independent panel of eminent personalities, and they recommended that Africa must set up its own responsive mechanism to prevent conflicts. That led to the adoption of Article 4H, which then gives the AU the right to intervene in internal affairs, but without referring to the UN Security Council as the authoritative agent that can legitimately grant such intervention. So in my contribution in the legal framework of regional humanitarian intervention in Africa, and also the role of the African Union Continental Early Warning System, I examined these two regional frameworks and the African Union Continental Framework, and highlighted how some of these inconsistencies could prevent Africa from actually being able to implement a sustainable peace prevention, conflict prevention, and peacekeeping resolution mechanism on the continent. To be sure, Africa was not the only region to embark on acts of illegal international legal reform during this period. NATO's intervention in Kosovo in 1999 can be regarded as another act of illegal international legal reform. The reason is because, not only because that intervention was unauthorized, but because after the intervention, the Commission on Kosovo that was set up by the European Union described that intervention as illegal but legitimate, whatever that means. And if you scrutinize this closely, the argument was basically that even though this was a legally unlawful act, it was nonetheless a morally worthy cause that was justified by the necessities of humanity. So the combination of these acts of illegal international legal reform over several decades led to the production of several soft law, including several United Nations Secretary General reports, Boutros-Ghali's Agenda for Peace, Kofi Annan's two major reports, and the independent commission reports that led to the establishment of the responsibility to protect. All of them put together in 2005 produced what we now refer to as the World Summit Outcome Document, adopted by the United Nations General Assembly. That gives us an indication that illegal international legal reform may sometimes be a useful way of bringing about reform in international law when the world is facing a crisis. At the peak of 2011, the Arab Spring, I revisited this issue in my paper on emerging powers and the operationalization of R2P in Africa, the role of South Africa in the UN Security Council. Looking at R2P back then and the crisis of the Arab Spring, I had responded to that crisis by arguing that R2P cannot respond to the kind of crisis, not because as a normative concept it did not have the ingredients to respond to that kind of conflict, but because the international legal order itself was defective in fundamental ways, and it would not be able to respond. I guess today in 2025, we can substitute the Arab countries with Ukraine and Gaza, and that assessment will still be correct. My conclusion was in response to an article published by Professor Alex Bellamy and Paul D. Williams, who had claimed that even after the intervention in Libya, R2P was alive and well. And my own assessment was no, R2P is in fact in a coma. And if it ever emerged, it will have suffered irreparable damage. Although rejected by the international powers, are now shaping the new world order, China, Russia, India, and the US, The adoption of the Rome Statute was also another attempt to reform the international legal order. The adoption of the Rome Statute, which was largely supported by African countries, had hoped that the international criminal justice system would produce a new set of rules and institutions that would be able to hold everyone accountable, regardless of stature. It has turned out since the establishment of the ICC that this expectation was misplaced. So, and that goes to the very constitutive document of the Rome Statute. So in my publication in the Netherlands International Law Review, I had argued that those who constituted the court knew that it was never going to be possible to have an independent and impartial international court of justice. Why? Because the relationship between the court itself, as it is defined in its agreement with the United Nations as an institution, states that while they respect their own boundaries as separate international organizations, the Rome Statute still provides that the UN Security Council has the authority to refer countries to the ICC. The UN Security Council is not a member of the Rome Statute, a member of the ICC. It's not a signatory to the Rome Statute. So it is difficult to see how a judicial organ can claim to be independent and impartial when it is subject to a political organ. And we can see how that has played out in attempt to refer different countries to the ICC. It is only the enemies of or those who are considered as outlaw states that are referred to the court by the UN Security Council. So, in my last paper that has addressed this subject is International Criminal Justice, the Handmaiden of the Contemporary Imperial Project, a 12 perspective of some arenas of contestations. I then try to look at why the international criminal justice system is not working and tie it in with why Africa, or the face of international criminal justice on the dock, looks so dark. And my argument was basically to identify 4 arenas of contestations, and that why those arenas of contestation did not happen by accident, including the contestation over selectivity of who is prosecuted, the contestation about the category of international crimes that are identified, and the contestation about how international criminal law itself is used for political purposes. And the bottom line I argued was that this may again force Africa to resort to extra-legal ways to bring about moral reform in the law. So we see this in the Malabo Protocol, which Africa adopted in 2014. Yet it has not attracted the necessary ratifications, but we see that by setting up a parallel institution on international criminal justice, there is a likely chance that by the time this court becomes effective, and with the ICC exercising jurisdiction on one side as a universal court, and this African court exercising jurisdiction over the same crime, then there is likely a point of conflict where decision will have to be made as to the ultimate institution that is responsible for prosecuting particular crimes. And the last, so we'll just come to this shortly. The last critical moment I identify is the Ukraine moment as a critical juncture. And when I speak about the Ukraine moment, I'm not referring just to the 2022 February invasion of Ukraine by Russia, but I refer to a series of events that had put pressure on the international legal order over a long period of time, to such an extent that even those who are most optimistic about the resilience of this legal order are beginning to have some doubt. In 2023, Professor John Dugard published an editorial in which he highlighted the danger that is facing the international legal order. And one of the major problems he identified is the current situation where Western countries are pivoting away from international law and more towards a rules-based international order, in which no one really knows what a rules-based international order is, because even those who propose it have no coherent definition of what a rules-based international order is. So, for purposes of moving ahead with reform in international law, we can say that the kinds of pressure that different illegal acts has put on international legal order, whether it's in international humanitarian law or international human rights law. We can speak about questions of torture as interrogation technique. We can speak of the extraterritorial use of force against non-state armed groups, whether or not there is a right of preemptive use of force or anticipatory self-defense, as it were, and the legality of all of these acts under international law. But the bottom line is that in a moment of crisis, international law has shown that it can be reformed, not necessarily through the formal process of law reform, but sometimes through illegal processes, and that itself can lead to an improvement in the law. The phenomenon of illegal international legal reform has basically that embedded in certain illegal international acts is a seed of potential that could produce a future new international law rule, provided certain conditions are met. So we see right now in the Ukraine moment, as I call it, new centers of powers are emerging, BRICS, the Shanghai Cooperation, where the West appears to be pivoting away from international law and towards the rules-based international order. That would perhaps ultimately endanger international law as we know it. Illegal international legal reform and Africa's response to this Ukraine moment. Africa will be a part of whatever system is going to emerge. But the question will be whether Africa will be at the table or whether Africa will be on the table. You can be, Africa can be on the table or at the table. If it's invited to the, and it's at the table, it will be an equal participant. But if it's on the table, then it's apparently going to be a sacrifice from what we learn of history. Optimists argue that it is unlikely that the entire international legal order will collapse at once. At best, they argue, or rather project, that we could witness a gradual dissolution and replacement by different kinds of legal orders. And it's interesting that one of the major possibilities or scenarios described is the regionalization of legal orders. And one of my first publications addressing this issue has a possible way of organizing international legal system was regionalization. And it's interesting that this is being revisited because there is a likelihood that there would be not only a constellation of orders, but some alignments and orbits or zones of influence, if you like, that would might replace, I would say, this international system as we know it. In such a case, one would then think that the African Union should already start thinking about how it will respond. And the African Union Law Commission should then perhaps think of presenting, coming up with a framework on how Africa would fit into this new system. And I would just add to this proposition that in developing such a regional legal order or international legal order, Africa must rest on three key strategies. The first is assertive continental sovereignty. By this, I mean a strategy that requires Africa to exercise agency. The comments that we see or we hear in analysis of this issue seem to suggest that Africa will once again be at the will be in a system where it will be decided what Africa will get, and at the end of the day, no meaningful reform might happen, and Africa will continue to be a norm taker rather than a norm setter. In which case, it's going to once again be locked into a system where it cannot bring about any meaningful reform or change, however much it tries. So Africa will need assertive continental sovereignty, and that means it has to exercise agency. And it has many advantages in its favor, demographically, mineral resources, and its geography. So Africa needs to think critically about how it's going to fit into the emerging international legal order. I mentioned a second one, which is extra-legal international legal reform, norm entrepreneurship, which would require African states to first appreciate international law as a space of normative contestations, which is characterized by dynamic norm interactions. By this, I mean international law, when states go there, and the norms that exist normally will be set by powerful states. But again, as we've shown through history, African Union has been able to drive reform in certain areas by embarking on illegal international legal reform, which means it can actually exercise extra-legal international legal reform as a norm entrepreneur. It will be the first to introduce the idea of a regional organization exercising authority, first in the issue of peace and security, that may or may not require UN Security Council authorization. We've seen that in practice. Secondly, it will require Africa to recognize that such a system is bound to throw up dormant normative tensions from time to time. Those tensions, I argue, present opportunities for illegal international legal reform. And finally, I argue that Africa should rely on decolonized continental, or develop a decolonized continental international legal policy. What I mean here is that, first, it means resistance to further fragmentation. And secondly, a decolonized continental international legal policy must seize the ongoing reconfiguration of international order to center Africa, move Africa from the periphery to the center. And that, I argue, would require a united Africa to speak not from the margins of international law discourse, but from an authentically African identity. And finally, it means centering Africa in international law epistemology. When we teach international law, we teach it more or less in a positivist sense. I'll use Malcolm Shaw to teach international law, use Ian Brownlee and major textbooks of international law. You can hardly bring about reform if that is how we continue to teach international law, because the books themselves don't produce much in terms of critical scholarship that addresses the concerns of African states. So we need a new vocabulary. These texts and texts like those, they are useful books They're good for teaching international law the traditional way, but then we need a new vocabulary, and that includes lawyers and and judges having a rethink about how we teach international law. And just to quote, lastly, Judge Abdulkawi, who said that it may indeed be observed that the persistent recourse to colonial language and to concept of colonial law by the court implies a legitimation and rehabilitation of colonial law, or the 19th century public law of Europe. This is not a tradition I think we should continue. Africa needs to enrich and create new vocabulary for teaching international law. Thank you.
Thank you, Prof. E. That was an experience. Thank you for taking us on a tour de force. And I just want to take this moment to say two things. When I think about you, I'm not going to go emotional. When I think about you, I think about humility. And I thank and praise the Lord for that, for also bringing you into our lives at the African Center for Transnational Criminal Justice, at the faculty. But I also think about, on the left and right-hand side of me, research excellence, and you embody that. And you mentioned critical scholarship, and that is what you do. And we are hoping for more books to come, because you've opened up our eyes at the center. The students are sitting here, some of them are being supervised by you. What a privilege to be supervised by you. I also co-supervised a doctoral student with you. It was an absolute pleasure. You are brilliant. Now, I have the absolute honor to welcome Prof. Strydom, who is a world-leading expert in international law. I cannot think of anybody better to respond to your lecture. Please, Prof. Strydom.
Professor Double, other deans, staff, faculty of law, Professor E, and family of Professor E, students, I'm honored to be here. I was very fortunate when I became, I think it was in 2013, the incumbent of the South African Research Chair for International Law at the University of Johannesburg, to have John Mark as one of my first postdocs. He's a hard-working man and very diligent. And that is why he could stand here today and give this inaugural lecture. And I think that is something that students who aspire to that position should take note of. So, I'm here to respond to this very thoroughly researched and well-presented lecture. Now, what is a respondent doing? That is the question I asked myself when I started preparing for my worth of 2 cents to what is a very comprehensive and a very, very thought-provoking discussion, debate on the way forward in times of crisis. But there is a context within which I have to respond. I understood from the little bit of communication I had with Professor E that this is, at least in part, still a work in progress. So if I take that as my point of departure, my engagement today with this lecture and with the author of this lecture is to engage with him, or with the subject matter for that matter, in a scholarly way, and to provide perhaps a few viewpoints or reflections on some of the issues. I say some because in many respects I fully agree with main elements of the inaugural lecture. But there are some areas from a scholarly viewpoint I think we should perhaps in certain contexts also reconsider in terms of clarification of terminology we use and for other reasons. And I'm doing this also in the hope that it may create further opportunities for developing this debate, which I think is a very important one. So this is my whole intention, and I will be brief. I'm just going to select a few issues where I think we could engage further on and possibly refine the debate to steer it in a certain way, or to acknowledge that maybe it needs reconsideration. That is what scholarly engagement should be about, I think. So my focus will be on the three sources of the current crisis that we have, and I'm just going to mention them very briefly. The one is the issue about just and fair application of substantive and procedural rules of international law. I'm not going to comment on that. It has been fully covered. Second one is the legitimacy crisis of the United Nations Security Council, and everybody knows about that who is actively involved in this subject matter. And much of the functioning, or the original intended functioning of the Security Council, has been destroyed since 2011. The last time, if I recall, was when the Security Council was able to function. In all the conflicts, Syria, Ukraine, and Gaza, the Council was totally unable to function because of either the veto of China or Russia or the United States of America lately. So I just want to say one thing about the crisis that we have here. It is a crisis of legitimacy also because of the control that only 5 member states, the permanent members, exercise over the functioning of the Security Council. But I think we should also be thinking about what would it mean to expand the membership of the Security Council to whatever number. Should we then, to every new member, also provide the veto right? I don't think that is a solution personally, because then there will be more opportunities for using the veto. I think the only way forward on this specific issue is to see to it that certain crises in the world should be exempted from the exercise of the veto. But it's just an opinion from the side. I don't think that the 5 permanent members will ever accept that. And in order to bring about an amendment of the United Nations Charter is one hell of a difficult process. And you need eventually the consent of the 5 permanent members, which I don't think will happen. But just that is a side remark. The third one, and that is the one that I will eventually concentrate on also right at the end, and I will explain why, is the credibility crisis in respect of the unresponsiveness of international institutions and systems to the needs of developing world, and in particular of Africa. And the examples have been dealt with. I'm not going to deal further with that. Now, if we take into account the crisis, then, and this I think is the main part of the inaugural lecture, the substantive part of it, how should we go forward? And in particular, how should Africa go forward with that? And the concept that has been developed by Professor E in this regard is the concept of illegal reform. And when I first read it, I thought, but well, this is a contradiction, and I wrote to him, but then he explained to me what he had in mind. And this is a concept that has stayed with me while I was preparing for this response, and when I read not once but several times through the inaugural lecture. And this is what I want to engage with him tonight. And just to bring about a few perspectives that may cause us to rethink whether it is always necessary or useful to use the term illegal reform. Now, in carving out a different role for Africa, the lecture introduced the concept of illegal international legal reform, which, so the argument goes, could in certain cases bring about the required reform or change that is needed. Put differently, through an internationally legal act, a new international rule could come into existence to remedy the mischief and restores trust in the responsiveness of the international legal system. And I especially want to focus on this part of the lecture because I think that is where the essence of it all lies. And I'm not going to deal with all the examples. I've selected, I think, only 3. The one is the example used in the lecture about the practice that is developed in the United Nations Security Council to give, by the Council itself, to the progressive interpretation as time went on to the powers of the Security Council. And there's a long debate about this. Can a body like the Security Council use auto-interpretation to extend its own powers? That is the issue. Now, there are very sort of different views on this, and some scholars have said, yes, it is possible to do it because it happens in many instances. So, and one of the expanding categories that the Security Council has come to cover by means of this expansive interpretation of progressive interpretation of its own powers is the meaning of what constitutes a threat to international peace and security. And if you read some of the recent, not very recent, of a few years ago, Security Council resolutions on this, even something like the outbreak of the Ebola epidemic is classified by the Security Council as a threat to international peace and security. So I do not know whether that is indeed the correct interpretation, but nevertheless, that is what the Security Council has said, and it has also done so in many other instances. Okay, but I think the essence of it is not which categories can be included. It may become problematic at one point or another. I think the main issue here is whether a body, in principle, is entitled to provide a progressive or reach a progressive interpretation of its own powers and then apply it to a new situation. And I think it is possible because all powers and functions given to an entity or a body that has to perform certain functions undergo changes over time to accommodate new developments and so on. So I think from a principal point of view, it is entirely, in my understanding of it, a lawful exercise to do so. So, and if it is a lawful exercise, I don't think we should unproblematically read into it as a form of an illegal act that changes the meaning of things over time. Okay, that's all I want to say with regard to that issue. With the rest about the Security Council and the issues about how to respond to threats to international peace and security, the examples are perfect, and I fully agree, John Mark, with you on that issue. The second one I have selected are the African examples, because I think this also makes out a great part of the lecture is to how, the question is how is Africa to be positioned in order to move forward in this critical moment that we're experiencing. What should it do? And here again, critical sort of developments have been mentioned, and I'm just going to take the one about ECOWAS. and his military interventions in Sierra Leone, etc., a while ago. And those familiar with the UN Charter, when a regional body like ECOWAS, or for that matter the African Union or others, decide to take enforcement action, it has to first seek the authorization of the Security Council for that intervention. It's clearly stipulated as such in Article 53 of the UN Charter. Now, and in this instance, there was no attempt made to seek authorizations from the Security Council. And another perfect example was the bombing of Kosovo. In that case, why didn't European forces not seek prior authorizations from the Security Council? Because even before the matter went to the Security Council, and this illustrates the point, both Russia and China have said that if this matter comes to the Security Council for authorization, we will veto it. So the European forces knew, NATO knew beforehand, it will serve absolutely no purpose. But we have a massive crisis here of humanitarian proportions and the potential killing of thousands of people. We have to do something. And they went in, and that's how the bombing occurred. And the outcome was, well, in terms of the charter, it was an illegal event, but it was morally the right thing to do. That is the most clear-cut event of an illegal act that had consequences. But let's come back to the ECOWAS examples and similar ones. When the matter becomes complicated in calling it an illegal event is when the Security Council decides, in terms of the formulation it used in its resolutions, to give the impression that it has implicitly authorized that intervention. And that is in fact what happened in one of these cases where the Security Council didn't condemn it and said, whoa, ECOWAS now has acted in clear violation of Article 53 of the UN Charter. But it addressed the issue in a way which gives the interpretation that the Security Council was okay with that. So then again, the debate is that the right thing to do? Shouldn't the Security Council be clear in its resolution and not sort of use terminology which makes it a little bit uncertain whether it has or has not given its blessing to this matter? Now, again, this developed into a fantastic debate amongst international scholars, some siding with the implicit option and others say no. The Security Council should be forthright in its reaction to interventions of this kind. The point I want to make is that if we accept that through the formulation that the Security Council uses in dealing with instances of this kind gives the impression that it, by implication, gives its blessing to it, then if that becomes the practice of the Security Council, again, I think we should be careful to refer to it as an illegal act, because then it has the authority of the Security Council. So both the examples that I mentioned reflect on, I think should urge us to reflect on the clarity of reform terminology that we use, because it may change from circumstance to circumstance. In one instance, it might be quite clear that the Kosovo example. In others, it may be a little bit moving into a gray area, and that we have to then adapt our terminology in order to accommodate those changes. The last item that I've chosen from the inaugural lecture before I come to my concluding remarks is the Africa's concern with the International Criminal Court. Now we know what the issue is here. There's been a long-standing dispute between African countries and especially the African Union as well with the ICC concerning two issues. The one is the the immunity of sitting heads of states under customary international law, and the other one is a strong focus on prosecutions in Africa. The latter one has changed, or is changing at the moment. Not completely, but we see there are other situations being investigated. But that's not what I want to talk about. I want to refer to the example given in the lecture on the African response to this by means of the Bamako, not the Bamako, the Malabo Protocol, sorry. And we know that the Malabo Protocol has still not required the number of ratifications for it to become into force and effect. And the one extraordinary aspect of the Malabo Protocol is that it has expanded the types of offenses that will come under the jurisdiction of the court once it comes into operation. So apart from the ones that we normally refer to as atrocity crimes, war crimes, crimes against humanity, genocide, the expanded jurisdiction will also include crimes such as the unconstitutional changes of government, environmental crimes, terrorism, etc., organized crime, and so on. Now, this is just one aspect of the Malabo Protocol. The other aspect, I think, is probably problematic one, and for that, it has become, it has received a lot of criticism, and that is the expansion of the categories of persons that will enjoy immunity for those crimes. So we know normally that in terms of the development of international heads of state and government for crimes of this kind, they cannot hide behind immunity. But this protocol expands that category to also include other government officials without specifying which category. So it's an open-ended classification. So, and I think it is that a development that is not progressive, but it is regressive in terms of the development of international law. And I would hesitate to use that, unreservedly as an example of a reform process that is extraordinary or out of the ordinary or even illegal. But that, I think, is probably also a point that we can take further once the court becomes operational. I have to say here that I doubt whether this court will fly, and I will say why. An international criminal court is far more expensive than a human rights court. And I don't think the African Union has the financial backing to put this court in place and to let it function. And I think that is perhaps, it's not the only, but it's one of the reasons why the ratifications are so low. But things can change over time. The African Union may, in the course of time, fix its budget and may have the money to take this further. That brings me to my conclusion. And I want, in my conclusion, return to the credibility deficit that Professor Iyi quite correctly mentioned, and relating to the inadequate responsiveness of the international institutions when it comes to concerns of Africa and other developing countries. Now, I have to say that in dealing with a credibility issue, I'm going to play the role of devil's advocate in a sense. And I want to commence with the following question, which holds up the mirror for the other side of reform. And the question reads as follows: isn't there so much more that African states and institutions can achieve in the form of ordinary reforms that are in any event an integral part of their legally circumscribed mandates and functions? So this question, I think, may also have implications for the concept of assertive continental sovereignty. Professor E.G. mentioned as one of the three pillars of Africa's approach to a new international legal order and to bring about reform. And I want to explain this. I have many examples. I'm just going to use one, dealing with the reform initiatives of the African Union institutions. Now, a new process of reforms kicked off in 2017. There were others before. The reform proposals were not implemented. The new ones, which started to be debated in 2017 and developed, have still not been implemented. Now, in 2017, the AU Assembly mandated Paul Kagame, the president of Rwanda, to prepare a report with proposed institutional reforms that would enable the AU governance system to become more capable and addressing the challenges facing the Union. And Paul Kagame was given the function to speed up the reform process, to identify the issues that have not received the proper attention, that have not been implemented. Now, after he has done his work, he investigated the situation, he invited comments from African states, he did research on it. He came to the following conclusion at a meeting of the AU Assembly sometime after that. And he listed the following as still outstanding issues and which hampers the African Union to perform its functions diligently. He said there's a chronic failure to see through African Union decisions, and that has resulted in a crisis of implementation. Secondly, there is a prevailing perception of limited relevance to African citizens. The AU is a fragmented organization with a multitude of focus areas. There is an overdependence on partner funding. Underperformance of some organs and institutions is due to unclear mandates and chronic underfunding. There is limited managerial capacity, lack of accountability for performance at all levels, unclear division of labor between the African Union Commission and other bodies of the African Union, and inefficient working methods in both the African Union Commission and the African Union Assembly. What further needs emphasis is following assessment of the decisions that are taken by the African Union Assembly. At the time when he presented his report to the Assembly, he said there has been adopted more than 1,500 resolutions by the AU Assembly. Yet there is no easy way to determine how many of those have actually been implemented. By consistently failing to follow up on the implementation of the decisions, the signal has been sent that they don't matter. As a result, he concluded, we have a dysfunctional organization in which member states see limited value, global partners find little credibility, and our citizens have no trust. Now, when his term came to an end, he was replaced by President Ruto of Kenya to take up the baton and to once again try and solve this situation concerning the non-implementation of reform proposals. Now, I'm not going to deal with the detail of Ruto's report. It was of a similar kind. And he also suggested that the matter should be addressed at the 2025 meeting of the AU Assembly in February, and that all outstanding matters at that occasion should be resolved. This was not done. In 2025, when the AU Assembly met, there was not enough done in order to do exactly what Ruto recommended. and it was now postponed again to February 2026 for hopefully a final solution of the matter. So I'm mentioning this development within the African Union itself. And I think when we talk about taking reform forward and placing African states not on the table but at the table, there should be introspection of a serious kind, also from the side of the African Union and other African Union institutions, in order to show that it is taking the problems on the continent seriously, that is doing its best efforts, it's exercising due diligence to resolve those issues, and that it deserves respect at the table. I want to conclude with a few personal remarks. John Mark, you deserve this position. You've worked very hard for it. You demonstrated yourself as a solid researcher and a scholar of international law. And I want to also congratulate your family who's here for the support they've given. And for that reason, it was for me a great opportunity to join in this occasion. And I wish you all the best in your future career. Thank you.
Thank you, Prof. Strydom, for that very critical response. We now have the opportunity for the vote of thanks, and this will be delivered by Prof. Benjamin Mesmoor, our Deputy Dean of Research. Thank you, Prof.
I usually say I'm vertically challenged, so I have to set this up properly. Good evening, everyone. It's a pleasure to be here, all protocols observed. And it's an absolute honor to do the vote of thanks here. My task is straightforward, and I promise I won't stand in the way of you and excellent refreshments and photographs outside. The title, Beyond Crisis and Credibility in International Legal Reform, Africa at a Critical Juncture. It could not coincide better as today marks the opening of the general high-level debate at the General Assembly in New York. If you want to get a sense of this crisis, you just need to log in and listen for no longer than 5 minutes. And I wish we were able to share the link for this public lecture to some of the leadership across the Atlantic. The golden rule is don't do to others what you don't want them to do to you. But the golden rule that we're currently dealing with is the one that says one who owns the gold makes the rule. And that was almost presented in full picture by the inaugural lecture today. The lecture is also a reconfirmation that this stand on the right is not just only a slogan. It's also the lived reality of colleagues within the faculty. The research that we engage with is not just blue sky. It actually has implications in the lived reality of people. Emphasis on the word people on the ground. Now, on the personal thank yous, I've been to, I think this is my 7th inaugural lecture this year. The meeting starts on time, ends on time, flows almost seamlessly. The lights, the online platform work. No one has to scream, "You're on mute." People find themselves to the venue, the gowns, the waters, the flyers, the list is long. Nothing is by default. It's by design. It's not AI. There are people behind all this, including the people who cleaned this for us. And this very safety that we enjoy because of the security colleagues outside. Some of whom we know by name, others I feel we should try to know them as much as possible. Let me provide a non-exhaustive list of these excellent people. I want to start and end with the man of the moment, Professor E.G. So at this moment, I would like to ask my colleague Tracy to share a very small token of appreciation with Professor E.G. It's Murphy's Law. There you go. So I'm going to continue with the personal thank yous. The university's management, under the leadership of Professor Balfour, Professor Halahala, Professor France, Professor Madiba. The registrar's office, the deputy registrar was here. The 6 faculties and colleagues from the 6 faculties that are here. Definitely Professor Stridham. Absolute pleasure to actually have you here and to provide that critical input. The dean, my dean, he's often the host, but he doesn't get the thank yous often. And managing our faculty so efficiently, so effectively, is not a walk in the park. So thank you very much. And in the dean's office is Miss Davids, who committedly utters the words, "I'm so blessed," every single day. It's contagious. And we want to thank her for that. Hazel, Herschel, Adelaide, Vernon, Nhala, Kay, Ezel, Wendy, Lizel, Tracy, Lumko, student assistant, without whom I don't know what we would be. Tracy, Nosi. I know most of them will have a good night's sleep today, aware that we're probably the only faculty, and I'm going to repeat that, probably the only faculty that pulled off a back-to-back inaugural lecture in an excellent manner. With all the departments, units, institutes, students, and other guests present. Wendell was a superb MC. Now, let me focus back on Professor E.G. and his family. I realize that we are here to mostly honor academic scholarship and intellectual rigor, and I get that. And there is no shortage of that in Professor E.G. In fact, he often reminds me of the saying, the only place where success comes before work is in the dictionary. But academic excellence without character, without Ubuntu, would be incomplete. And so I'm happy to say that Professor E.G. is generous with his time. He's warm, he's kind, he's accommodating, he's understanding. In short, he thinks human, and he acts human. In January 2020, the dean and I had the privilege to meet with him. To be exact, 13 January at 10 a.m. at the dean's office. We had a conversation with him. We were not surprised, but impressed that he's more than fit for purpose for the task ahead. He seemed to have not just only the IQ, but also the EQ. This morning, I sent a WhatsApp message to John Mark asking if there is anyone specific you would like me to thank, and he sent me a text. Professor Gartz Abraham, my PhD provider. Professor Henny Stridham, my postdoc host. He said, I also want to thank Weber Wenzel for supporting my doctoral studies at WITS, and the NRF Sachi Chair International for supporting my postdoc at UJ. But I'm going to put this one in a quote, and he added, I would like to thank my siblings, especially for their sacrifices for my education. I thank my wife and our children for coming into my life, and I appreciate the stability their prayers and support brings. So as a final gesture of thank you, can I please ask all of you that are not named John Mark E.G., and those that are not necessarily family members. So the family members and Professor E.G. sit down, and everybody else, please stand up. Professor E.G., you sit down. Thank you for a change. So let's just, yes, the family is here. they're sitting down. Thank you. So let's just clap and thank them for everything. Thank you very much. You can remain standing. I hand over to the MC. Thank you.
Thank you so much, Prof. Mesmer, for the vote of thanks. And this is now the end of the program. Can I please ask you to stand again? We will now have the procession leaving, and afterwards we will have some refreshments outside. Thank you so much. This is very special, and enjoy your evening. Enjoy the public holiday tomorrow.